Okay, well, good afternoon, and thank you for joining me today for Lunch with Mia. My name is Kathleen Borain, and I serve as the Maryland Insurance Commissioner. The Maryland Insurance Administration is the state agency that regulates the insurance sold in our state. Our team at the MIA is here to help you when you have questions or concerns about insurance, including questions or complaints about claims and coverages. The Lunch with Mia series is designed to tackle specific timely issues of concern or interest to the public. And the topic for this session is a very important one, the Federal No Surprises Act, which went into full effect on January 1st this year. This act seeks to protect you from receiving large unexpected bills from healthcare providers who provide necessary care that you need, but who are not in your network. So under normal circumstances, we plan our care in advance. We select providers who are in our network, meaning that they have agreed to accept what our insurance company pays, subject sometimes to a deductible or a copay. If we want to see a provider who is not in the network, we know that in advance, and we make that choice with knowledge that we will have to pay the difference between what our insurance company is covering and what the provider charges. That difference, the balance that has to be paid after insurance paid, is referred to as balance billing. Sometimes, however, we are not in a position to choose our provider. So for example, if you're taken to an emergency room, you're not choosing your provider in those circumstances, not the ER practitioner, or maybe the radiologist, or heaven forbid, the surgeon or the anesthesiologist. You have no way of knowing in those circumstances whether your provider is in your network or not. You only know when, surprise, you receive a balance bill. That is what surprise balance billing means. The balance you receive from a provider that you may never even have met. It occurs in emergency rooms, and it can occur in a hospital or a care center where some of the professionals on staff, say that radiologist, for example, is not in your network, but you would never know that. Your doctor's in the network, your hospital's in the network, but that particular professional may not be, and you don't know that until you get the balance bill. Some states, including Maryland, have already had laws or regulations on the books that protect patients against surprise billing in some cases. The federal law is broader. In addition, state laws don't apply to what are called self-insured plans. And most people who get coverage from their employer are in what are called self-insured plans. So that's where the Federal No Surprises Act comes in. It protects members of insured plans and self-insured plans, and it establishes minimum protections that apply no matter which state you are in. During this session, our consumer education team at the MIA will look at some of these new protections and the rights that you have under this very important new law. So thank you for joining us today. I hope you find this information helpful, and I'm going to turn the program over to Patty Dorn. Thank you, Patty.
Thank you, Commissioner Bryan. For this program today, I'm going to be asking our Chief of Life and Health Complaints, Mary Quay, several questions about the No Surprises Act. For the event today, please leave your microphones and your phones on mute, and please keep cameras off. There's going to be a Q&A session at the end after Mary has finished answering my questions. Please put questions in the chat box. You're going to see a chat box. You can put your questions in there, and you can put questions in anytime Mary is speaking. You can continue to put questions in after I start the Q&A as well. In the chat, if you put questions in the chat, please make sure that your questions are addressed to everyone. So there are more than one of us monitoring the chat, and so please address them to everyone. But if you do have questions that you don't want to place in the chat, they're personal for whatever reason, you can use the email address that's going to be on the screen later in this program, and then those questions will be answered after the event. This session today about the No Surprises Act is devoted to consumer questions, and we're going to be holding a provider presentation with the Health Education and Advocacy Unit of the Attorney General's Office in March. So those details are going to be on our website, and I'm going to give more details at the end of the program. So with that, I'm going to welcome Mary Quay.
Good afternoon, and I'm Mary Quay, Chief of Life and Health Complaints. And this presentation is for consumers to give a very general overview of the balance billing provisions of the No Surprises Act. And I'd like to start by explaining some of the terms I'll be using. An emergency facility may be an emergency department in a hospital, or it may be a freestanding emergency room. A participating or in-network provider is a facility or healthcare practitioner who has a contract with your insurance company and accepts the insurance company's allowed amounts as payment in full. Cost sharing means the portion of this allowed amount that you pay, and it may include your deductible, co-payment, or co-insurance. Your cost sharing amounts may be different for in-network and out-of-network providers. And I'm using the term insurance company to refer to different types of companies, including HMOs that offer health plans.
All right. Thanks, Mary. So this first question is about emergency care. So the question, can you take a couple minutes and talk about emergency care? What types of bills could a consumer receive if they go to the hospital and receive emergency care?
So Maryland law has had some consumer protections for years, and those protections remain. The No Surprises Act adds additional protections. Most people who don't have experience with the healthcare system think of an emergency facility or a hospital as one entity, with all of the services provided by the facility or its employees. In fact, the doctors, labs, and other departments may be separate providers who bill your insurance company separately. And some of these providers may be out of network. In an emergency, you should only have to pay as if these providers are in network. Now, an emergency usually means that your symptoms are severe. If you are experiencing severe pain, for example, chest or stomach pain, or if you are bleeding and it can't be stopped, generally those are considered emergencies. In an emergency, you should go to the closest emergency facility. Under the No Surprises Act, you are covered from the time that you start treatment in an emergency department until you have been treated and are able to travel without using medical transportation, like an ambulance, and are in a condition to understand waiving your rights and protections. During that time, you pay only what you would pay an in-network or participating provider, even for the providers who are out of network. Once you meet the standards for understanding the notice and for giving consent, you can waive your protections. If you continue to see out-of-network providers after waiving the protections, the services will be treated as out-of-network. Now, you can also switch to an in-network provider so that you don't have to pay the out-of-network payments. Some types of providers can't ask you to waive the protections. We'll talk about them a bit more later. Your insurance company cannot require prior authorization before you go to the emergency department or charge you more because the facility isn't in your plan's network. You will have to pay any in-network deductible, co-payment, or co-insurance that apply. After your insurance company has paid the claim, you will get an EOB showing what you owe. If you think that the amount you owe is too high, for example, it shows you owe out-of-network cost sharing, you should contact your insurance company and file an appeal. The Health Education and Advocacy Unit in the Office of the Attorney General can help you file an appeal. If you are not satisfied with your insurance company's response, you can also file a complaint with the MIA, and we can assist you if we have jurisdiction over your insurance company. If we don't, then we can tell you where you can file a complaint. Back to you, Patty.
Thanks, Mary. All right, so the next question for you. This is about in-network facilities. So what if you receive a bill from an out-of-network provider when you received treatment at an in-network facility?
Okay, and this can apply even when it's not an emergency. When you go to a facility, such as a hospital or an ambulatory surgical center that is in your health plan's network, you are protected from surprise bills from the practitioners who treat you. You might plan surgery at an in-network facility. Sometimes the facility will be in-network, but providers they use might be out of network. For example, an anesthesiologist. The No Surprises Act provides protections to make certain that unless the patient consents to pay higher charges, the services will be at the in-network rate. You can never be asked to waive your protections and agree to pay more for out-of-network care at an in-network facility for care related to emergency medicine, anesthesiology, pathology, radiology, neonatology, or for services provided by assistant surgeons, hospitalists, who are the doctors who focus on care of hospitalized patients, or intensivists, the doctors who care for patients needing intensive care, or for diagnostic services, including radiology and lab services. You can still agree in advance to be treated by an out-of-network provider in some situations, such as when you choose an out-of-network surgeon knowing that the cost will be higher. The provider must give you information in advance about what your share of the costs will be. If you sign the consent form, you'd be expected to pay the balance bill as well as your out-of-network coinsurance, deductibles, and copays. And if you have questions about this, you can contact the No Surprises Help Desk in the Department of Health and Human Services or the Health Education and Advocacy Unit.
Thanks, Mary. The next question for you is about air ambulances. The question is, what fees are consumers responsible for if they're required to be transported to a hospital by an air ambulance?
Under the No Surprises Act, the consumer will only be responsible for in-network deductibles, copays, and coinsurance, even if the air ambulance company does not have a contract with the insurance company.
Thanks, Mary. All right, and the next and last question for you is about appeal rights. Healthcare providers and insurance companies are supposed to give notice of your rights. Out-of-network healthcare providers are supposed to give notice and get consent. Insurance companies have to send a notice about your claim. It can all get confusing. So, Mary, can you briefly describe what a consumer can do if they believe they have not received an appropriate notice about their rights to appeal or their ability to waive protections under the No Surprises Act, or if they've been billed too much for a service?
So first of all, your health plan and the facilities and providers that serve you must give you a notice of your rights under the new law. If you think your healthcare provider should have given you a notice but didn't, you can contact the Health Education and Advocacy Unit or the U.S. Department of Health and Human Services at the No Surprises Help Desk. and we will have a slide with the contact information. If you've received a surprise bill that you think isn't allowed under the new law, you can file an appeal with your insurance company or ask your insurance company for an external review of the company's decision. The MIA can help you with decisions the insurance company made in processing your claim. If your health plan is subject to Maryland law, if your health insurance card says MIA on it, then Maryland law applies to your plan. Even if Maryland law does not apply, the No Surprises Act might. In this case, you can contact the U.S. Department of Health and Human Services to file a complaint. You can file an appeal with your insurance company and a complaint with the MIA or the U.S. Department of Health and Human Services if you think your claim was processed incorrectly, leading to bills you shouldn't have to pay. For example, if you went to an in-network hospital, but the claim for lab work was applied to your out-of-network deductible, or if a doctor had you sign a consent form to waive your protections before you were well enough to understand it. And those are things where you can file a complaint. The Attorney General's Health Education and Advocacy Unit can help you file an appeal with your insurance company or a complaint with the MIA, or can help with a healthcare provider who is billing you in violation of the law.
Thanks, Mary. I am going to get started with the Q&A session, and it does look like we have questions in the chat already. So that's great. Keep them coming if you have other questions. So I'll just say welcome to this Q&A session. We're going to try to get all your questions answered today. It's only 1:20, so we have plenty of time. But just as an FYI, this session will end promptly at 2 o'clock. And so if there are questions that we don't get to, please note that email address that should be on your screen right now. This lhcomplaints.mia@maryland.gov. That's also where you can send your questions if you if you don't want to post them here. So personal questions, just something that you don't want to post, go ahead and feel free to send those to that email. So I'm going to get started with the first question. The first question for you, Mary, who pays if you don't have insurance and go to the emergency room?
Well, that's something that is not covered by the No Surprises Act. It is something that you would have to work out with the emergency room.
All right, thanks, Mary. The next question is, what if the provider is in network, but the facility is out of network?
Yes, that's another situation where the in-network provider would still have to honor their contract and pay based on what or accept payment based on what the provider contract says between the provider and the insurance company, but the facility would not be bound by that. And what we're calling ancillary providers, like the lab and the anesthesiologist, would also not be bound by the No Surprises Act.
Thanks, Mary. Next question. What are the Maryland laws that you mentioned that are already on the books to protect citizens?
Well, this gets a bit complicated. If you're a member of an HMO, then members of HMOs are protected from balance billing by Maryland licensed providers. And there's a whole statute about how they get paid and what you can pay, but you should not be balance billed by a Maryland provider if you're in an HMO and under a Maryland policy. There are laws about if you are seen by an on-call physician who accepts assignment of benefits. There is also a law that applies to ground ambulances that are operated by local or county governments. And I'm leaving out some detail, a lot of detail actually, and giving examples here. It's a lot to get into off the top of my head, but those are some examples.
Thanks, Mary. The next question, what if you refuse to sign? Will the physician or the hospital refuse the individual service?
So in an emergency, you cannot be asked to waive your protections until you meet the criteria. And those criteria include various things, but they're really focused on, can you move to another facility without using medical transportation? Are there in-network providers available? Are you able to understand the consent form? Is the consent form in a language that you speak and understand? So if it is not an emergency and you want to seek treatment, they do have to give you notice of what the costs will be, but they do not have to treat you if you do not agree to that. And did I answer that? I think I'm trying to get into details without being too overwhelming, because there is a lot in this law and we're trying to give a very general overview for people. But we can always follow up questions with emails if someone wants more detail.
Thanks, Mary. And then again, to those of you attendees, if Mary answers your question and you do have a follow-up question, just go ahead and you can put that in the chat as well. So the next question is, can you provide the email address for the No Surprises Act Assistance Department? I'm just going to say before Mary answers, at the bottom here, we don't have an email for CMS, but we do have the website and the help desk number written. But let me see what Mary has to say about that. You're muted.
I'm not aware off the top of my head of their email. They probably have one through the website, but I don't know it offhand.
Okay, thanks. Next question. What is the contact information to seek help if you receive a large bill from an out-of-network after a visit to the ER in Maryland?
Well, this can get a bit complicated, and it's unfortunate some of these things are so confusing. If you are getting a large bill because of the way that the insurance company processed your claim, first you would want to appeal with the insurance company, and then you would want to file a complaint with the MIA if Maryland law applies to your plan. And even if they don't, we can see where you can go. Now, if you're receiving a large bill and it's from the provider and it's not based on the EOB, that would be the Health Education and Advocacy Unit. And one thing to be aware of is that the No Surprises Act applies to services after January 1st. Or on or after January 1st of 2022.
Thanks, Mary. How does the No Surprises Act affect those insured under Medicare?
I believe that it does not apply to Medicare. It applies to federal employees, self-funded ERISA plans, and insured plans.
Yeah, I think this next is a follow-up to a previous question where Anne says she received a huge bill from the hospitalist at Frederick Memorial Hospital.
Yeah, and that would be something to follow up with. Again, as I said before, it may be an HEAU matter or an insurance company matter, but this law will only apply to services starting in January.
All right, thanks, Mary. I did ask you about a refusal to sign. I asked you that question? Okay. So my next question is, what if a person goes to an out-of-network ER, but has to be admitted after?
So this goes to what I was talking about, until you can travel without medical transportation. And when you're able to understand, the No Surprises Act applies until you're stabilized, and that includes services after you're admitted. It's not only when you're in the emergency department, but then it stops once you go for surgery or are admitted. It applies until you meet those criteria.
Next question. I signed a payment plan for dental services, but the EOB is less than the amount I contracted. What recourse do I have?
That's something I would suggest contacting the HEAU about, because it sounds like it's a dispute with your provider. It's not really a matter under the No Surprises Act, but they can help with disputes with providers.
All right, thanks, Mary. Are you also protected from balance billing with a PPO?
Sorry, it took me a second to hit the mute button. Yes, this would apply where you would not be balance billed and you would only pay your in-network amounts when the law is triggered.
Can the patient obtain a copy of the participating provider agreement between the healthcare provider and the health insurer?
Typically, no.
All right. Gwen B, I see your question, Mary. My question related to the waiver. Just FYI, is that make sense, Mary? Go ahead, Gwen, if you want to clarify.
Oh, yes, it was. It was relating to the waiver. Say if I went to a facility within my network and they got my insurance card, got that, and they come back, with the papers to you sign for, for the treatment, whatever the treatment is, and then within those documents they may have a waiver. And so that was my question earlier. What if the patient, me, refused to sign that waiver based on what Mary said earlier?
Okay. So if it's not an emergency, they can say that, no, you need to go see someone else or to go to an in-network provider. Typically, this is not going to be like the kind of waiver you may have seen in some of your documents. Federal law, the federal government has provided a template of the waiver. And so it can't be a paragraph buried in the documents. There's something that gives you the healthcare costs. And we're not getting into all those details right now. But it will be something that is distinct from the other paperwork. But if it's not an emergency and it's not one of those types of providers, the ancillary providers at an in-network facility, they can say, no, we won't treat you unless you sign it. You'll have to go to an in-network provider. And if you can't find an in-network provider, you'll have to work that out with your insurance company of what to do.
Oh, sorry, again, I don't mean to take over the meeting, but no, I'm always looking to make sure I'm in network. I'm not one to just go out just to willy-nilly because I don't want no surprise bills. But I think you're misinterpreting I'm saying that I'm going into a network, but you got some, you're in a hospital emergency room and they surprise, throw that surprise waiver in the mix. So my question is, within the network, can I refuse that waiver? I'm already in the network.
Okay.
Okay. So sorry.
Okay, no, that's fine. An in-network provider should not be giving you a waiver and consent form.
All right. Thank you, Mary.
Thanks, Mary. Thanks, Gwen. The next question, are emergency room physician practices allowed to refuse to bill the patient's health insurer, Care First?
That is something I would not expect to see happening because I'm not sure how that would happen going forward because they still would face the prohibition on billing an insured patient.
All right, thanks, Mary. The next question, can you expand on your answer, typically no, to my question, can the patient obtain a copy of the participating provider agreement between the healthcare provider and the health insurer? And why not, in that the patient is a third-party beneficiary of the contract?
Yeah, I think we're getting beyond the scope of today's topic. So that is something, if you can email us, we can address.
Okay, well, thanks, Mary. I do not see any other questions in the chat. Obviously, I'm going to give you some time if you still have some questions or some follow-up questions to go ahead and put them in the chat. If anyone in my group sees a question in the chat that hasn't been answered, if you can bring that to my attention. And Joyce Peach in the chat has put a couple links. One of them says to sign up to receive information about future presentations and future in-person events. If you want to be on our mailing list to find out about events like this that we have, that is in the chat where you can just click that link and put in your email address. And as well, in the chat, there is a survey. We're always looking for feedback. You know, how did we reach you? And what kind of topics would you like to hear from us in the future? Things like that. So if you want to sign up for future events, that's in the chat, as well as we would appreciate some presentation feedback, if you don't mind there. Let's see if there's any other questions. Okay. It doesn't look like it. But I do thank everyone for attending today. I hope it was informative. I hope you got the questions answered that you came here to get answered today. I just want to say one more thing. You might want to take the time to jot down that email address, that lhcomplaints.mia@maryland.gov, if you think you're going to have follow-up questions. And like I had said earlier, if there's questions that you're just not comfortable asking here, you know, feel free to email those. The information again for the Health Education and Advocacy Unit is there. Our information, as well as the U.S. Department of Health and Human Services, their help desk, and then the website for the No Surprises Act. And it looks like Joyce answered the question, will we get a recording? And so this recording is going to be posted. It will be posted on our website within the next couple of days. And I do have another question, Mary. I missed what you said about Medicare and the NSA. What if you are covered with Medicare and Medicaid?
Yeah, I don't think that the No Surprises Act applies to either. It applies to federal employees, self-funded ERISA plans, and to insured policies.
Thanks, Mary. All right, so with that, I just want to thank everyone for attending today. We will be back tomorrow for another Lunch with Mia. This one's going to be at noon. This is going to be a session about life insurance where we're going to answer some common questions that we get at the Insurance Administration about life insurance. And then in March, we're going to have another Lunch with Mia that is focused on answering healthcare providers' questions. And so the providers' questions, that event is going to be March 16th at 1 p.m. And that information is now posted on our website as well. That is www.insurance.maryland.gov. Just going to go ahead and that's actually, I was going to put it in the chat, but it is right there in the middle of the slide. So you'll see the information on our website. If you want to come back as a provider, if you're providers and you want to hear more about the No Surprises Act on March 16th, 1 p.m., find that additional information on our website. And with that, thank you everyone for attending, and we hope to see you at another one of our events in the future. Thanks so much.